The court is ready to hear argument in 19567, BPX Operating Company against Strickhausen from LaSalle County and the Fourth Court of Appeals District.
May it please the court, Mr. Hogan will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal.
May it please the court. More than 45 years ago, this court in Orem versus General American Oil Company of Texas examined a petitioner's claim that she did not ratify a lease when she accepted payments under that lease. The petitioner argued that although she'd accepted the payments, she never intended to ratify the lease when doing so. This court rejected that argument and held that whatever her mental reservations may have been, her actions in accepting the payments were inconsistent with an intent to avoid the lease, and accordingly, she ratified the agreement. The Court of Appeals decision in this case undermines that rule from Orem and numerous other Texas cases based on that same principle by importing an element into the defense of implied ratification that has not previously existed: subjective intent. Under the Court of Appeals decision, a party who knows that its counterparty has breached an agreement can knowingly and intentionally continue to accept benefits under that breached agreement, but nonetheless avoid ratification merely by claiming that they never subjectively intended to ratify the agreement. That is the argument that this court rejected in Orem, and this court should reject it here today. During my argument, I hope to make 3 points to the court about some of the issues raised by the Court of Appeals and in Respondent's briefing. The first is that the Court of Appeals change to implied ratification case law will upend settled expectations, particularly in the oil and gas industry, and ultimately result in the hindrance of the development of oil and gas in the state of Texas. The second is that this court's decisions in Hooks and in T.S. Reed did not add or establish a new no challenge element to the defense of implied ratification. Rather, the court properly noted that implied ratification in that case could take place based on 2 different set of facts: the acceptance of benefits or the failure to challenge the transaction at issue. And third, that nothing in this court's decision in Fortune Production versus Conoco would allow the respondent here to accept royalties under the pooling agreement, but nonetheless sue for damages despite that acceptance. To move to my first point, ever since this court's decision more than 50 years ago in Montgomery versus Rittersbach, operators in the state of Texas have functioned under the belief that when a royalty owner knowingly accepts funds from a pooled unit, they have ratified that unit as to their interest. Cases like Hawkins and Yelderman only underscore this. The Court of Appeals decision, however, changes these settled expectations by adding in that element of subjective intent, which could have negative consequences for oil and gas development. Particularly today in the state of Texas, much of the oil and gas development taking place involves horizontal drilling, which requires the creation and production from long laterals that potentially and often do cross multiple tracks, which accordingly—
Mr. Hogan, I took the respondent to agree with you that that this element of intent could be proven by intentional conduct inconsistent with the lease, even though that's not inconsistent with not ratifying the pooled unit. But what would you point to as conduct that's inconsistent with ratification here, given the respondent's argument that she was entitled to proceeds from the lease anyway, since the wellbore was on her property?
Certainly. And there's 3 responses I have on this particular issue. There's one that's factual, conceptual, and then legal. Factually, the well that was at issue here was not just drilled on her property. It was drilled across the property on which her lease was located and 2 additional properties. So royalties were being generated not just from her track, but from 2 other tracks. And before she ever accepted a single royalty payment, she was told by petitioners that if she were to be paid under the pooling arrangement, as opposed to just for royalties off of her track, that ultimately would result in her receiving more money. And so she's not just receiving royalties, as she claims, from her own lease, she's receiving it from multiple leases.
But is there a dispute about how those royalties would be calculated? I mean, does she have to take your word for it as far as how they'd be calculated just from her lease, or what's the state of the evidence on that? And is it, can we say as a conclusive matter in order to support summary judgment that she would have gotten less without pooling?
Well, so the only record before the court evidentiarily about how much production came off of her track versus how much she received from the pooling agreement comes from the affidavit of Carter Davis, who did confirm that in fact she received more in royalties proportionally from production based on the pooled unit basis than she did from production based on her well. There is no evidence to suggest any other calculation is accurate. And so yes, the evidence before the court can show and conclusively shows that is the case. Additionally, as a legal matter, the Springer Ranch decision from the Fourth Court of Appeals talks about how another way to potentially measure damages or production in instances like this can be the length of the horizontal lateral that is located on her property. Even under this basis, the length of the productive wellbore that actually was bringing in oil and gas on her property is again smaller than the amount that she did receive on a pooled unit basis. The other issue that we have here is conceptually, it is a pooled unit. And so ultimately, when there is a pooled unit that's created and you accept royalties from that pooled unit, if there's oil and gas production on other parts of that unit, you are necessarily accepting under Texas case law on pooling royalties from other properties. And
yeah, but actually, Mr. Hogan, the letter that you sent her in this case said, we want you to ratify the pooling of the unit. And if you don't, then we're going to need the parties to sign on to this production sharing agreement. And it seems to me then the letter itself is evidence that even absent pooling, she would have been entitled to royalty payments from the production at this well. It was just going to be calculated differently and require a production sharing arrangement, which seems to me, for example, to undercut the position that I think you take in your briefing that absent pooling, there could have been no production at all from her property.
Well, absent pooling, the evidence in the record shows that no well would have been drilled on her property because it was too small to drill a horizontal well. So it's less that there's no evidence that there was no production from her property and more evidence that but for pooling, because of the nature of horizontal wells, there would have been no well eventually drilled here.
But the well was drilled before the ratification, right?
The well was drilled before the ratification.
So that was just a mistake.
Yes, it was a mistake. It's a situation, though, where although there's a claim, obviously, that she believed she was entitled to more royalties and had a failure to understand how much payment she was entitled to, there were summary judgment briefs filed on this very issue where the petitioners outlined exactly how she was being paid and how she was being paid more. And even after this summary judgment briefing, she continued to accept the royalties. I also think that if you look at, obviously, the Court of Appeals case in Gelderman versus McCarthy, that undercuts this argument. But additionally, this court's argument, or this court's decision in Hooks and T.S. Reed also doesn't work with the idea that she could continue to accept royalties and not be in an inconsistent position.
Unless she took the position that she was entitled to those payments despite or even without ratification, because number one, she would be entitled to royalties from the production on her land, which even your experts' numbers, although they conclude that she was entitled to more with pooling than without, it's a very close number. I forget what it was, but 52 to 46 or 48 or whatever %. And so she could have taken the position that look, you owe me all of this anyway, number one, just as royalties, but you also owe me more because of the damages for the loss of opportunity for, claiming retained acreage and the other things that they argue. So, it just seems to me that conceptually, setting aside the specific facts of what she said or did not say here, she certainly could have said, look, you owe me this much money, so I'm hanging on to this, but I don't want to be part of the pooling.
Well, so that was the argument that the lessor made in Gelderman versus McCarthy, and actually wrote on the checks saying, I'm only accepting this as partial payment for what you owe me. And nonetheless, that was still ruled to be ratification. So certainly under that fact pattern, her position is indistinguishable from Gelderman, who did lose. But
isn't that why we say in Hooks that there needs to be no challenge to the amended unit, because just the acceptance of the money alone wouldn't be inconsistent with the pooling, with the amendment of the pooling, and you need that additional element of not, in that particular case where just the acceptance is not inconsistent, you need that additional element of not challenging the amendment?
Well, in Gelderman, there was always a challenge to the pooling as well. But in Hooks, there's actually two separate discussions that take place with two separate citations about what could constitute ratification. One of the citations is to silence or inaction that could lead to ratification. That would be the lack of a challenge. The other is
the silence has to be inconsistent, right? Yeah. I mean, if we're looking back to waiver case law, and we seem to be pretty consistent on this, the inaction or the action, whichever it is, depending on whether it's waiver or ratification, has to be inconsistent with claiming the right. And so if just the acceptance is not necessarily inconsistent, it seems like the non-challenge is what you have to have in order to show the inconsistency.
Well, so factually in this case, respondent's argument that she challenged repeatedly the pooling does not actually line up with the record. There's an initial challenge to the pooling, but after the letter explaining that the pooling would result in more royalties to her property, she then took more than 1 year's worth of royalty checks, over $500,000, without ever lodging any additional challenge. So it's not a situation where there is a repeated over and over again challenge. But
was her counteroffer a challenge?
Now, her counteroffer would have been something that the parties could have resolved separately, but there was never any kind of deal that was reached as to the counteroffer.
But did that indicate her disagreement with your characterization of what she was owed?
So, excuse me.
Go ahead.
I believe that what you could characterize it that way, but the acceptance of the royalties again all took place after that point. So it still is part of this initial challenge to the pooled units, where she initially says, "I don't want the pooled unit here," but then afterwards, 3 days after that letter, in fact, deposits royalty payments and continues to do so consistently and without any kind of additional objection. And so there was an initial challenge. That's certainly not in dispute, but it's a situation where later there was no further challenge that took place. It was simply the acceptance of royalties without a challenge. But I think if you look at Hooks versus Sampson and Hooks and the T.S. Reed case, you can find a situation here where this court, if it had examined the same kind of arguments, would not have reached the outcome that it did. For example, that was one where you had a set of plaintiffs that had been pooled, and then they had been unpooled from that lease and pooled in a second pool. They accepted royalties from the second pool, and they claimed that they were entitled to both those royalties and royalties from the first pool. And so arguably their behavior in the case in accepting royalties from the second pooled unit was not inconsistent with their challenge that they were entitled to royalties under both. But just because you are entitled to some form of royalties isn't the question at issue. In fact, this court's decision in Daniel versus Gozel is a very good example of this, admittedly in the fraud context, but involving ratification. In that case, you had a plaintiff who accepted benefits from a retirement agreement and later sued to set it aside. When the defendant claimed ratification, the plaintiff said that he hadn't ratified because he would have been entitled to the monies that he received regardless. This court said that that is not the proper inquiry for ratification. Rather, the inquiry is, did he know about the acceptance of benefits, and did he then take the acceptance? And that is the instance before the court here. And so I completely agree that the challenge could very well, or the lack of a challenge could be the basis for a ratification claim. But I don't believe it's necessary for such a claim, or that this court made it so.
Chief, if I may ask one
Yes.
question, so that respondent can have a chance to respond to the answer here. But if we were to disagree with you and conclude that she has not ratified the pooling, will her previous acceptance of these payments cause any harm to your client?
So yes, in the sense that it is funds that they have overpaid to her under what she would actually be owed under the contract if there was no ratification. Respondent has said in the briefing before this court that she's owed an amount of money under the Browning Oil versus Lukey case, an amount of money that's equal to the reasonable calculation of production from her property. She's received more than that amount of money. And so she has in fact been overpaid here. And it's a situation where funds that would have otherwise been entitled to the operators have gone to the respondents. And so yes, there would be a harm associated with it. I also, if I may make one additional point.
You may finish.
Thank you. I do think that this is something where the settled expectations of the industry could have effects for additional wells on units that have been pooled, but where there's a question about the challenge of the pooling later. This track being a good hypothetical example. There's one well drilled across the 3 tracks that we have here. However, because there's a question about whether pooling actually exists or not, operators are going to be hesitant to pay $10 million to drill an additional well when there's a question as to subjective intent. If an operator doesn't know the issue of subjective intent, which they just simply can't because it's subjective, they're going to be hesitant to drill any additional wells where there's a question of a problem related to the pooling, even when there's been an acceptance of royalties from the lessor. That's going to leave oil and gas in the ground, and it's going to hinder the development of those resources, which is against public policy.
Any other questions? Thank you, Mr. Hogan. We'll hear from the respondent.
May it please the court, Mr. Garcia will present argument for the respondent.
May it please the court. To err is human, to ratify is for the 9 members of the Supreme Court to decide. I'd like to mention why this case, the facts of this case do not lend themselves to ratification generally, and then why ratification does not fit the horizontal drilling of oil and gas wells, and then touch a little bit upon how an opinion on ratification of horizontal well drilling and wrongful pooling could affect the industry or be minimized. And I think from the questions earlier during petitioner's argument, the court has homed in on the correct issue, which is inconsistency. Ms. Strickhausen did nothing inconsistent with challenging the wrongful pooling of her lease. She didn't challenge the validity of her lease. She challenged the pooling of her lease. The well was drilled on her property and on 2 other properties. So as the court mentioned, she would have been entitled to royalties regardless of whether her land was pooled or not. From the record in this summary judgment appeal, the hurdle we have to clear is about as low as they make hurdles. So
Mr. Garcia, what do you say to the argument that she would not have received royalties because there was not enough there? They would not have drilled.
Well, yes, I think that was something that the lessees brought up after the fact. They leased Ms. Strickhausen's property. They leased the other 50% mineral owner, the Crouch property, and then the surrounding property. So I think the idea was to pool. The other leases allowed for pooling. For some reason, this lease didn't have or it allowed for pooling only with the consent of the lessor. And as we know, the lessor the lessee, for whatever reason, overlooked the need to get pooling authority and pooled anyways. So I think it was an error on the lessee's part to drill the well without ensuring that it had authority to drill. And then after the fact say, well, we wouldn't have drilled if we didn't have the right to pool, is blaming Ms. Strickhausen for a mistake, an error that the lessee made. But I think as a general proposition, it is true, horizontal wells will in all likelihood, generally speaking, not be drilled unless there's pooling because of the distances involved.
So, Mr. Garcia, what is the specific evidence in this record that your client challenged the pooling? I know that at the beginning, a letter was sent that noted that pooling required her consent and she had not consented. Was there any other expression of a challenge after that first letter?
Your Honor, I think there might have been an email from Ms. Strickhausen's lawyer, Mr. Armstrong, but repeated letters continuing with her objection or restating her objection. The record doesn't have any information. The timeline of events that we laid out in our brief shows, of course, the well was drilled, pooled. Ms. Strickhausen was contacted by a landman asking for a written ratification. She then went to her lawyer. Her lawyer wrote the lessees and asked questions as to whether or not her land had been pooled. And then we got the Duval letter that was referenced with regards to Mr. Armstrong, Ms. Strickhausen's lawyer, being told that there were two methods to pay royalty, either tract participation or length of perforated lateral, and that her royalties would be suspended if she didn't agree to one of those two methods. Mr. Armstrong responded, and then there was no reply to that from the lessees, and the royalty check was sent. So when the royalty check was sent, it wasn't accompanied with a letter saying, Ms. Strickhausen, we've done what we said we were going to do in the Duval letter. It was just the check that was sent. So it was fair for Ms. Strickhausen to assume my lessee told me they weren't going to pay me unless I signed a ratification, yet they've paid me anyways. So perhaps they've abandoned their insistence on paying me without a ratification. So as I mentioned earlier, the fact that she took the check and cashed it was not inconsistent with her challenging the pooling. It would have been inconsistent with her challenging the lease. If she'd have said her lease terminated, then of course cashing the check would have been inconsistent. But because the well traverses her property and produces from her property, accepting the royalty is not inconsistent.
Did the check refer to the pooled unit by name, White Kitchen or something like that?
Yes, there was a reference to WK unit number 1, but there was nothing else accompanying the check that would have indicated it was from a pooled unit. That it was just that one reference on the check itself. And for purposes of the summary judgment record and the evidence in this case, the petitioners took a strong position in saying that the cashing of the royalty check standing alone is ratification as a matter of law. And the answer to that question in reality is cashing the royalty check is a ratification sometimes, which is very anticlimactic. But in this case, we don't have evidence. Ms. Strickhausen wasn't deposed. Her lawyer wasn't deposed. So we don't know there's nothing in the record to say what she was thinking when she received the check. And if the court looks at the amended summary judgment in the record, there's a footnote that mentions imputed knowledge, that what Mr. Armstrong knew might have been imputed to his client. But as the court knows, in ratification, you have to have actual knowledge, not constructive knowledge. And there's no briefing and there's no argument or evidence saying what was told to Mr. Armstrong can be imputed on to Ms. Strickhausen. Ms. Strickhausen just cashed the checks. That's all the record shows. And when she cashed the checks, again, the timeline of events, the letter explaining how her royalties were going to be calculated was not sent contemporaneously with the check. There was nothing with her check that said, this has been paid pursuant to the track participation basis. So the record here is devoid of that type of evidence. So ratification wasn't proven as a matter of law because we don't have an inconsistent act. We don't have any evidence of intent, whether the court thinks there are 2 elements or 3 elements to ratification. We would argue that there are 3 elements, that ratification is very similar to waiver, which has been called the other side of the coin. It's similar to acceptance of benefits, and some of these other affirmative defenses that turn on inconsistent conduct and intent. I mentioned earlier.
What do you say to the petitioner's argument that accepting the check was inconsistent with your position that there was no pooling, or that you weren't going to ratify the pooling because the amount that you received is more than you could have received had you not ratified the pooling?
Our response to that would be, we don't know. That would be a disputed fact question. The lessee.
If we have the Carter Davis affidavit saying that you got royalties of 50%, even though it would have been 47% just from her property, is there controverting evidence indicating that that there's a fact issue on that what she got could have been, and what the check she cashed could have been amounts that she would be entitled to even if there was no pooling?
I'm not aware of any evidence. I know we had there was an expert affidavit attached to the summary judgment response saying that there was a need for discovery to examine and figure out how royalty would be calculated. But as far as directly on point, I don't think there's anything in the record, because of course the summary judgment was filed relatively early on. No depositions had been taken. We had the lessee saying unilaterally, there are 2 methods to pay you, and we think we've paid you more. And Ms. Strickhausen was deprived of an opportunity to investigate whether or not how much she would have been entitled to in the.
Well, there's no argument. You've not raised any argument in this case that the trial court erred by granting summary judgment without first allowing sufficient time for discovery. So I mean, I think we're stuck with the record we have here. And it just seems to me the record we have here, as Justice Busby points out, the only evidence in terms of what was more favorable to your client in terms of the amount of the royalty is that pooling resulted in a more favorable arrangement. And so then that leaves me wondering, even if we agree with you that there was a breach of the pooling agreement or non-pooling agreement and no ratification or waiver, I'm having a hard time figuring out what her damages could possibly be.
Well, that's correct, Justice Boyd, and candidly, we just didn't get that far. We were responding to the affirmative defense of ratification and focusing on the 3 elements, and we hadn't developed the evidence on damages. The Luecki opinion says you're entitled to a reasonable or a share of the production that came from your property that can be calculated with reasonable certainty. And there are these 2 methods of calculating royalty, but without metering on those actual perforations, it's impossible to know exactly how much production came from your land. So you're right. If there had been, if before the court was a final summary judgment, this is a permissive interlocutory appeal. If the issue before the court was whether or not we had damages and it was a no evidence summary judgment on damages, well, then I think you're right. We might have some problems with the record, but because the court granted the summary judgment on ratification, damages really weren't considered at that point. The court was saying Ms. Strickhausen acted inconsistently, and she had knowledge, and she was stopped from saying she didn't intend the act of cashing the check. So we never got that far into the case to really explore what amount of damages we were entitled to.
So if we agree with the petitioner here that your client ratified the pooling so that she is, as a matter of the law of the case here, she stuck with the pooling arrangement, we would render that decision and remand it back to the trial court. Would there be anything left for your client to pursue at that point?
I'm not sure. I think if she's ratified the pooling, the question as to what exactly did she ratify was something that also wasn't explored. She received the checks. And of course, the cases on ratification say you have to have knowledge of all the material facts. So she got a check. That's what the summary judgment record shows, and she cashed it. But there was no evidence that she received the designation of pooled unit. So the boundaries, the dimensions of the pooled unit, how many acres on her property were included in the pooled unit, things of that nature. There was no summary judgment evidence on what she knew. That might be one issue that would need to be resolved. But barring that,
to me, she, by cashing the check, she's ratified under the petitioner's theory, assuming that cashing the check constitutes ratification regardless of subjective intent or, regardless of at least an initial challenge or objection. If that's the case, then she has accepted not only the pooling, but the amount of the royalty owed to her as a result of the pooling by cashing those checks.
correct. I mean, if receiving the check and knowing that it had to do with pooling is enough, and if that knowledge therefore binds you by ratification to the dimensions of the pooled unit and everything associated with the pooled unit, then the majority of the case is probably resolved if she's ratified the pooling. That is the majority of the case.
So one question I had for you is, there's a section in your brief, I think it's section 9, it comes towards the end of your respondent's brief, that argues that the contractual language, the lease is no pooling provision, and the other two provisions of the lease prohibit pooling under these facts. But the Court of Appeals held that the contractual language is irrelevant to the resolution of ratification here. And you've not challenged that holding by filing a cross petition. And so I'm just wanting to make sure that I understand your position. On the one hand, the Court of Appeals says the contractual language doesn't matter, and you haven't challenged that. And yet on the other hand, you seem to argue that you think the contractual language does matter. So help me understand what we should do as a court with regard to your arguments regarding the contractual language.
Well, the subject of the interlocutory permissive appeal was whether or not there was a ratification. And again, whether she acted inconsistently. We gave all of the pertinent language to the court by way of background. But with respect to ratification, solely looking at ratification, I think the court could look at the contractual language to see if her conduct was inconsistent or not. It wouldn't be relevant to what knowledge she had when she cashed the check or what her intent was at that exact time, but whether she was acting inconsistent with her lease or not, given the lease language. I think that would be the only way the court could look at it. And you're correct. When the appeal was taken from the summary judgment order, we didn't seek permission to appeal the court's construction of the lease. The trial court said the no pooling provisions have been breached, but that really doesn't matter because the breach has been ratified. The other point that I had, or the other issue that we had wanted to touch on was the unfairness argument that the petitioner's been making, and the suggestion that the opinion of the fourth court somehow upsets implied ratification law generally or in the oil and gas context. I don't think there was any information or briefing to suggest that oil and gas lessees are rampantly breaching pooling provisions and are oftentimes finding themselves in breach of a pooling provision and looking for assistance or a remedy from the courts, such as ratification. We think the breaching of the pooling agreement is an accident or a mistake, and not something that is troubling oil and gas production or oil and gas exploration. Again, in this situation, if the court looks at the record, the oil and gas lessee made a mistake in pooling without obtaining authority. They asked for a ratification, they didn't get it. The lease provided that if undisputed royalties weren't paid, the lease would terminate. So the lessee wanted to pay something. The lessee could have paid an amount that was undisputed because the well was on Mr. Strickhausen's property and left any difference in suspense to be the subject of the litigation. But the lessee wanted its cake and wanted to eat it too. The lessee said, we're going to send a royalty check that not only will perpetuate the lease, but will also force Ms. Strickhausen to either ratify or to forego her royalties and sue and face years of litigation and expense without receiving her royalty check. The situation is analogous to the court's opinion in Kramer versus Castleman, which was a divorce case where one spouse was allowed to receive some benefits under the divorce decree and still challenge it on appeal as long as the challenge wasn't inconsistent. The oil and gas lease in this case being similar to a divorce decree insofar as it defines the relationships of the parties. If the lessor is entitled to the royalty, and there was a question with regards to whether or not the lessee's been harmed, the lessor can always, if it's overpaid, either credit future royalties that are due, and the lease has provisions for whether or not a recoupment of overpayments can be pursued. So the lessee wouldn't be harmed if it's paid royalties under a provision that it later finds out might have overpaid Ms. Strickhausen. But for the lessee to make a mistake and then, rather than try to fix the mistake, capitalize on the mistake and put the harm on Ms. Strickhausen and say, you either accept this royalty check and ratify what we've done, or you'll receive nothing. And so to argue that this is a lessee that's being taken advantage of, or that Ms. Strickhausen was laying behind the log and trying to capitalize on this situation is incorrect.
Any other questions? Thank you, Mr. Garcia.
Thank you.
Mr. Hogan, I believe you have 5 minutes.
Thank you. May it please the court. One issue I'd like to bring up.
Mr. Hogan, you might want to turn your video on.
Yeah, excuse me. I have to press a button there. One issue I'd like to bring up is a case that we haven't talked a lot about, which is this court's decision in FM Stigler. This court, again, in that decision, talked about the need to look at inconsistent behavior in the ratification context, this time of a principal and agent. But I think it's important, this court noted and cited directly Section 96 of the Restatement Second of Agency, where the restatement says that if a party receives or retains the benefits of an unauthorized transaction with knowledge of the facts, such conduct constitutes an affirmance of the entire transaction, irrespective of a manifestation of intent not to be bound by the liability it imposes. And so the restatement is picturing a situation where you could have someone who's accepting the benefits of an agreement while at the same time claiming, I don't have any intent to ratify. And it states that in that situation, ratification nonetheless takes place.
But if it were that simple, then the statement we made in the Sansom case, Hooks, is irrelevant. Under your theory in Hooks, if the defendant had in fact objected and challenged, then it wouldn't have mattered anyway.
Yeah, I believe that in the Hooks case, if the fact pattern had said that there had been no challenge, but they had just accepted the royalties, that would have been a situation that also could have called for ratification. The flip side of the coin is that if they had not accepted royalties but never challenged the transaction, that also could have been implied ratification. The court cites two separate standards when talking in Hooks about the inconsistent actions. And the two standards that they cite are an action to do something inconsistent or an inaction that's inconsistent. The acceptance of royalties counts, but so does the failure to challenge the unit altogether.
Right, but under your theory, if you accept royalties, then whether you challenge or not is irrelevant. Is that
If you know, yes, if you knowingly accept royalties from an agreement, the intent to challenge.
Going back to the inconsistency issue, you mentioned FM Stigler, which I think is useful because what FM Stigler says was that the payment was, or the benefit received was the, quote, direct, certain, and proximate result of the unauthorized action. Do you agree that's the appropriate standard here? I mean, shouldn't we look at these royalty payments to determine whether they were necessarily the direct, certain, and proximate result of the pooling?
Well, I think that certainly the benefit that's being given to the individual that's ratifying, in this case, would be the direct and certain benefit from the royalty payments.
Well, but she's claiming, you know, that these were not direct, certain, and proximate result of pooling, but they were the result of production on my land under the lease.
So she claims that, but the record before the court shows that they were not only based on production from her lease, but also production based on two other leases and the pooled unit, and the fact that the well would have never been drilled without the pooling to begin with.
I'm thinking about when you sent your first check with $249,000 or whatever it was. It seems to me that under your theory, you agree you owed her $242,000 or something very close to that instead of 50%, 47% or whatever the numbers were. And under your theory, she even though she was owed $240,000, she had a check in front of her for $249,000, and your theory would require her to not use that money to which she was certainly entitled, the $240,000, for fear of ratifying the pooling that her lawyer had already objected to.
Well, at that point, in the same way that the plaintiff in Daniel versus Gozel, this court's case, was confronted with an election, she has an election to make. And that is, she can either accept the benefit under the transaction at issue and continue with that transaction, or she can reject the transaction and challenge it in court. The same situation that she was in before a royalty check had ever arrived in her mailbox. And so it's not a situation where she's able to claim, in this case, more than what she's owed, but nonetheless challenge the pooling after the fact. Instead, she's actually receiving additional benefits, but under a transaction. Oh, if I may continue,
yes,
Justice.
you may finish.
She's receiving benefits under a transaction and then trying to undermine the transaction through a suit later. That doesn't line up with the election case law. There is no case where this court or other Texas courts in this circumstance have allowed a challenge to a transaction to go forward after the acceptance of benefits, merely because the party claimed that they didn't want the ratification to happen.
Any other questions? Thank you, Mr. Hogan. The case is submitted and the court will take a brief recess.